Well, good evening. At this time, I will call to order the Board of Adjustments and Appeals meeting for November 28, 2018. Would you please rise as we pledge allegiance to the flag? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, at this time, we have a roll call, please.
Chairman Taylor.
Here.
Member Smith Rodriguez. Here. Member Johnson.
Here.
Alternate Member Kilpatrick.
Here.
All right, we have 4 members of a full quorum of 5, which we can do business. Do we want to ask the question again before we proceed about your speech to the applicant?
Sure. The information that I've provided previously to this applicant regarding the upcoming agenda item has previously been stated that Mr. Lois Ward as applicant has indicated that he requested a full membership in order to proceed with his application. And at this time, I don't know if that position has changed or not. But since that time, I would like to add that the city has decided to implement a policy to require any applicant that requests tabling that would also be responsible for the cost of advertising and the courtesy mailing to the notices, as the city has been absorbing those costs up to this time, and that's something that the city believes should be deferred to the applicant in the event that the applicant wishes for it to be continued to another meeting. And at this time, I would like to invite the applicant up to the podium to make that determination.
Good evening. My name is Lois Ward. I'm the applicant of this item. I need to have some clarification, if I may, first. The original hearing on this item had 5 people in attendance, and it was my understanding, and I'd like you to clarify, if you would, that at least 4 of those people that heard that had to be for the next hearing. Is that true or not true? That was stated, but I don't know if that's true.
That statement was requested by one of the board members, and I concurred that that would be an appropriate recommendation. I don't think that that is a requirement for this case to proceed, and furthermore, one of the members that was here has resigned from this board, and so all 5 are impossible to obtain in going forward. So given that, I know that a lot of time has passed, and so I would expect that you would do a refresher to the board members and for any board members who may not have heard the initial application in order to proceed with your presentation.
Okay, one more question. Regarding the fee, I have to state that I think it's terribly unfair for the applicant to be punished because we have a failure to have a full board. That's not his doing. And I know my client has spent thousands of dollars so far on this issue, and to be punished further, we don't think is fair at all. If you insist on a fee, we'll go ahead and get over with tonight, because it's not fair.
It would not be a fee, it's just the cost that the city has incurred as we have done previously, but going forward, it is a new policy that the city has decided to implement because these are costs that the taxpayers should not have to bear. It is related to this application, and it is all the cost of this application going forward. You have the right to ask this board to vote to table, and this board has the right to vote to hear the item tonight because it has been scheduled for this meeting tonight. So after you've made your request to table it or not, then the board will have the opportunity to make that vote. And if they choose not to table it, then the advertising question is not on the table, but it's just the cost of advertising that the city is looking to recoup.
Therefore, I would request that you table it and we not incur any additional expense because it's no fault of ours. We don't have a full board.
Brad, do you have any knowledge of the cost of advertising and the cost of mailings?
The application fee is, I think it's about $150 for the advertisement, but I have to take a moment to look for sure. And I believe Kim could probably concur.
The advertising fee is $150. The mailing, I do not know. The mailing, no.
The mailing is the cost of sending notices to the property owners within 100 feet circumference around the properties. And we have provided courtesy notices to those property owners each time this application has been tabled. And so it's really the cost of mailing.
Just a quick question. Does this, I assume this was city council that made this determination on the fees?
It has not gone to city council yet, but it will be forthcoming.
Okay. What my real question, though, is this applicable to applicants that are already in process? In other words, this case?
This is the first time an item has been continued 4 times, and this board has already decided to cancel your December meeting. And so you are outside of the scope of being able to table it to a time certain within 30 days, which is the recommendation that we have always had for any item being tabled into the future.
Right.
And if we have an item that's being tabled more than 30 days out, we do re-advertise. And so the situation that we're in is compounded by those facts.
All right. Thanks for that clarification.
Sure.
Did that answer your question, sir, as to what you?
I understand what I've heard, but our request is the same, that be tabled until your next meeting and no additional fees be required of the applicant.
All right, sir. Well, when we open it up, we will discuss that further.
Okay, that's fine.
Thank you, sir.
Thank you.
Okay. Approval of the minutes for, we have 2 different sets, September 26th and the October 24th. Are there any additions or corrections that anyone noticed on any of those minutes that we need to make changes of? Staff, they were okay with you? Okay. Do we need to vote on these separately, Counselor?
You can do them together.
Okay. So, do I have a motion to approve the minutes for September 26th and October 24th?
I move to approve the minutes for September 26th and October 24th.
I'll second.
All right, we have a motion and a second. All those in favor, please say aye. Aye. None opposed. Very good. All right. Now it's time for the little speech. All right. All persons who anticipate speaking on any public item must fill out an oath card to be heard on that agenda item and sign the oath contained thereon. These cards are located on the table near the entrance to the council chamber or may be obtained from the recording secretary. This meeting will be conducted in accordance to procedures adopted in Resolution 24-1997. Those speaking in favor of a request will be heard first. Those opposed will be heard second, and those who wish to make a public comment on the item will speak third. The applicant may make a brief rebuttal if necessary. A representative for either side, for or against, may cross-examine a witness. Anyone who speaks is considered a witness. If you have photographs, sketches, or documents that you desire this commission to consider, they must be submitted into evidence and will be retained by the city. Please submit such exhibits to the recording secretary. So we want to make sure, yes, I see that being taken care of. Confirming that all the agenda item for tonight has been properly advertised, staff?
They have.
Thank you very much. Have any of the members had reason to make further visits or speak to anyone in the public regarding this this evening?
No.
All right. Seeing no reply, we'll move on then. We have nothing under consent, and we have one order of old business. which is variance 6-2018, lots 1-7, block 62, revised plat of Indian River City. This particular is a tabled request from in the past that we have had full hearings on, and unless we invite the applicant, oh, no, excuse me, staff. Do we have any new information from our last meeting regarding this agenda item, sir?
Yes.
All right, if you will enlighten us, please.
So on page 13 of your packet starts the agenda item. At the last meeting, I just want to point out here for the record that this item was originally tabled at the August 29th meeting,
Yes.
and then again at the September 26th meeting, and then again at the October 24th meeting. At the August 29th meeting, this was tabled, or the application was tabled, to allow the applicant an opportunity to propose an alternative to the city street specifications.
Correct.
There was some discussion about that when this was originally brought before you. The city did not accept the applicant's street alternative. And so I included that as part of your agenda packet, and I'll point you to page 29 of your packet. And you will see the applicant's original proposal for street improvements to be accepted by the city. These were reviewed by the city, including the Public Works Department. And then on page 30 of your packet is the staff's reply back to the applicant regarding those proposed conditions of street improvements, that we did not accept those. I'm just going to state them here. The staff is not in support of the access conditions as outlined in your proposal based upon concerns about constructing any improvements in public rights-of-way which do not meet city standards. If you have any, and so I further mentioned that he could speak with the Public Works Director, Kevin Cook, who is here present to answer questions about this. Also, after a careful review, we determined that the prior variance application, which was withdrawn, was the least problematic for staff. That has been withdrawn, however, and so now we're left with the only variance application being presented to you tonight, which is variance number 6. The rest of the information here I have in that email is now irrelevant because of the withdrawal of variance number 4. I do want to mention also, too, that since this original presentation, that on, just going to get the date here for you, on October 9th, the City Council approved a resolution to vacate that portion, a 30-foot wide portion and I believe a 300-foot long portion of Parker Drive with conditions. And this resolution to vacate that portion cannot be recorded. It will not be recorded and therefore not effective until all the conditions have been adhered to. And so the conditions, I did not include that resolution as part of your packet here, since this action happened after your last tabling, I believe. But I will just summarize what some of those conditions included. That a fully executed access and utility easement over the entire vacated right-of-way would be agreed to and received. And so the applicant is going to have to, what we're asking is that the applicant agree to the conditions of the easement to allow the city any right to go on to that vacated portion of the right-of-way if it indeed does become vacated in order to access the utilities that may be in that area.
So kind of no fences?
We're basically, I'm sorry.
No way to obstruct flow of traffic or motion up and down that right-of-way?
Basically, we would discourage that. We are asking that we be held harmless from any responsibility of maintaining it or repairing.
Okay.
Even this would include, and I think the big issue was really a driveway, some kind of concrete surface there. That all necessary deeds, easements, and/or variances are obtained to ensure that the properties abutting the vacated portion of Parker Drive have legal access to a public right-of-way, so making sure that that is dealt with through the lot split process or any other kind of administrative process that we need to go through. Or if there is, as we go through this process, we realize there may be a need for an additional variance, that's dealt with. In the event that compliance with the conditions set forth herein is not achieved within 180 days, of the date of approval of this vacation, the resolution shall become null and void. So that's why it's not being recorded yet. It's not a recorded easement, vacate rather. The applicant will provide a survey of existing utilities. So it's, we're holding the applicant responsible for determining the actual location of the utilities in relation to the boundaries of the actual vacated portion of that right-of-way. They determine that, and we'll verify. The driveway will be located in an area that is acceptable to water resources. So in the event the applicant does go forward and put in a driveway or a hard surface to access these lots over this vacated portion of the right-of-way, then it will have to be located in an area that is acceptable to our Water Resources Department. So that's basically what has happened since the last time this was originally proposed to you. And that's where we are today. That resolution was approved by City Council, provided those conditions are adhered to, and they have a certain amount of time in order to do that. So, and then the applicant, again, withdrew the original variance, which you never heard, that dealt with possibly allowing for smaller lots or smaller flag lots using this portion of right-of-way as a flag stem. That is no longer being considered tonight.
Right.
What is considered tonight only is the variance application number 6, allowing these 2 lots, or the original lot, plus an additional one they want to create, to have frontage onto a public right-of-way that does not have a street. That's what's being considered tonight. So you're not considering the resolution of a vacate. I mean, strictly what you're supposed to be doing is considering the variance application on its merits.
I have a question.
Yes, ma'am.
Oh, were you?
Go ahead. That's all I had. Go ahead.
If the applicant complies with the conditions within the 180 days, and then the resolution is official, that would make the variance moot?
I believe that the variance would still would not be moot, because the issue related to, let me read the condition again, that all necessary deeds, easements, and/or variances are obtained to ensure that properties abutting the vacated portion of that driveway, of that road, Parker Drive, have legal access to a public right-of-way. So in other words, the issue then would be, the next question would be, who ends up owning that portion of that vacated right-of-way? Does it immediately go to the existing parcels there, and then what is the instrument then next if they want to create that into a stem to a future flag lot? They would have to create a deed to transfer ownership of a portion of that now vacated portion of Parker Drive to the other owner. Those issues have not been dealt with. So let's say this variance to you tonight is dealt with and approved. Those questions will still not have been answered.
Are there more questions? I understand everybody got to look at the tape or the CD, right? So we have knowledge of what transpired months ago, if we can remember that far back. All right, anything else to add, staff?
No, sir. I'll try and answer any questions you have. If you want me to reiterate or summarize anything that was discussed at that original meeting, I'll try and do that. We also have Public Works Director Kevin Cook here to answer questions as well.
The 180 days, was that from the start of the time that the City Council approved this, or is this the time of some what is that 180-day clock? When did that start? Was that upon approval at City Council?
I see it as approval by by City Council on October 9th.
October 9th?
Yes.
So a month and a half ago. And so 45 days or so are gone already.
Yes.
Okay. All right. Anyone else have a question for staff? Okay.
Yeah.
Yes.
One more. The proposed conditions by the applicant that the city rejected, it sounds like then the applicant said, okay, I'll just go to get a resolution then, because a lot of those conditions seem to be what you've also just described, right?
The resolution, the request to vacate that portion of Park Drive started this whole process. It was later then it was realized that probably another alternative they need to deal with is variances. So that vacate resolution had been considered from the start. It wasn't after the fact. The conditions you're referring to, though, about their proposal as an alternative to a roadway that, or a right-of-way that's improved to, with a street to city standards,
Right.
that was discussed at your first presentation, and you asked the applicant to propose an alternative. This is what was submitted to us on page 29 of your packet.
Okay. All right. All right, well, any other questions? If that's the case, then we will open it up to the public. And at this time, we do have one person to speak. So, Mr. Ward, would you please come back up and
Sure, and
address some of
Lois
these
Ward
issues?
again, applicant. First, I would re-request that you consider our request to table with no additional expenses, and if that's not approved, then we go home. If it is approved, we go home, and if it's not, we'll talk.
Okay, we've had a request from the applicant to table this because we do not have a full board present. Do we have any well, is there a motion so we can discuss it?
You may discuss it before making a motion.
May we discuss it? All right. All right, so we'll discuss it. Anyone have anything to add or say about it?
Well, I'd just like to simply add that I can understand the applicant's desire to have a full board. I definitely can empathize with that desire. So I think it's basically a whole unfortunate set of events based on what's happened with this board, as well as the back and forth between staff and the applicant, that are why we are the place we are, it seems to me. So I'm not, and it just so happens that the member that we are missing is our engineering and architectural board expert. So I'm kind of inclined to think that that we should table it until he's present, until we do have a full board.
Okay. Any other comments? Yes?
On the one hand, if we're a board of, that's 5 people and a quorum is 4, then we're certainly eligible to conduct business, and that it is what it is at that point. I mean, we each have our perspective and the code to follow and listen to whatever suggestions and the decision may be had. I understand the applicant's desire as well to have a full board. That may never happen because we can conduct business with 4. So we could be doing this for another year. And as far as the costs go, I think it was appropriate for the city to bear those costs in the beginning, because as the board, I know I was one of those people that said, hey, go back and try to negotiate something. But if this is now going to be an additional 3 times, on the one hand, I don't know what authority we have to even say the applicant should have to bear those costs if it's a new rule. But on the other hand, if we're going to keep delaying this because we don't know whether we're going to have 4 or 5 people, and the city continues to bear that cost, that's also inappropriate because we are eligible to conduct business today. I'm fine to table it, but I believe the applicant should bear the cost of the ongoing, at the very least, the advertisement fee, because that's a fee that we actually know. If the city cannot provide or staff cannot provide the cost on mailing, then the city can, it sounds like it would be negligible in comparison, but the advertising cost is clear and should be borne by the applicant.
Yeah, I'm kind of, I think that's probably fair.
I'm also happy to decide the issue today.
Yeah, I completely agree with that.
Okay.
So my suggestion, my vote would be to go forward today, to deny the applicant's request for a continuance. I am certainly willing to grant, to agree and allow to table the, variance, as long as the applicant bears that cost of advertisement. So I would leave it to him.
Okay. Yes, Counselor?
New information. I was able to pull up an email from Peggy Busaka, who informed me of the cost. I'm sorry, it was actually Brad too, Peggy. Somewhere along the lines, we found out that the cost of mailing for 70 to 75 notices would be approximately $26.
So we're talking about 150 and 26, was that correct? Okay.
The one other thing when, Brad, when you were mentioning earlier, connected with the resolution that the council would be doing, and it sounded as if there are other issues that will impinge upon this in the future, and that regardless of what we decide tonight or a future point and whatever, there still may be another turn that will affect what this applicant can do on that property. So I'm not sure, I'm not feeling that we actually have the entire scope of everything. In other words, in granting a variance or not granting a variance, what all would still be to come. Because, I mean, I'm thinking even if it were denied, as you said, there are still these other issues in play that I'm not sure what the outcome of those are going to be. So anyone else have a different opinion of what we've heard?
I mean, the reason there's an applicant and a variance is because the code either cannot or someone's choosing not to follow it. So, I mean, everyone knowingly comes before this board anticipating costs and additional variances and everything else. So, I mean, yeah, I don't think it's going to be resolved, and I think the applicant's going to incur a lot more time and cost, but that's the cost of doing business in front of the BAA.
Okay, everybody's had a chance to speak that wishes to speak. I'll turn it back to the applicant then on your request, sir. Would you consider us tabling if you had that expense, which we said it about $26, you said? Is that right? 20 plus the 150. The 150 plus the mailing of $26, because we're looking at, since we don't have a December meeting, we're talking about January. Would you consider us making that motion, sir?
Chairman, I do want to say, as it pertains to the mailing, my only concern with that, if we're having an estimated cost and it's less than that or more than that, I mean, we know a hard price for the advertisement is the 150. I mean, we know what that cost is.
Yes.
I mean, if we're saying that the mailing is going to cost $26 period,
No.
then that's one thing. But if we're just estimating, that doesn't seem fair to the applicant.
Yeah, it would honestly be floating $1 or $2, depending on if it goes to, what, 55 cents, they said, first of the year, or something like that, so instead of 50 cents, or whatever the postcard rate is. I mean, there are postcards, right, that are mailed out?
They're metered postcards at 35 cents.
Okay. At this time. So that could change just $1 or $2. What is your thoughts on us doing this kind of delay, sir?
If I may, I'll say it one more time. I'm clearly not authorized to incur any more expense regarding advertising or mailing. And our request is the same. If you can't table it with those conditions, then we'll go ahead and hear it tonight. That's fine.
Very good, sir. Thank you. All right, we've heard the applicant, so his request was to table it at no expense. Do I have a motion for that?
It would be to proceed with the hearing.
All right. We would proceed if this was denied anyway. All right, do I have a second?
I'll second that.
Okay. Roll call, please. Or,
Chairman Taylor,
yes?
Member Johnson,
Yep.
Member Smith Rodriguez. Yes. Alternate Member Kilpatrick.
Yes.
Okay. All right, so the table is off the table now. So we're going ahead with this variance. Now, I guess I'm still, in my mind, a little fuzzy on the city resolution, is what you're calling it, that was passed 45 or so days ago, back in October. how does that play? I mean, honestly, if we were to, if we were to approve this variance, and that, would that allow this applicant to build on those properties? Or are we gonna have to come back for another variance? To your knowledge at this time?
Approval of this variance as requested would allow them to have basically a drive, I mean, I guess they get building permits. Get the building permit for at least the existing lot that is fronting along Parker Drive. As far as the second lot that they want to create, that would have to be approved through a lot split, administrative lot split process by us. But we would be able to approve it because you would approve the variance for both,
Okay.
if you did it if that was
If
the
we did it
case.
that way. I mean, they don't have to come back. That's what we're asking. There's not a second because now there's a new lot.
Right. However, so let's say they go forward and get that, this is approved, and then the vacate resolution becomes null and void for lack of not committing to the conditions. They have the ability to put the buildings, or get a building permit there, and then as far as the building department, and I don't know, this is a little cloudy to me as well, it's about how they are going to be required to put in some kind of driveway, at least an apron.
You're talking about the applicant.
Right, for the new homes, but the question to us is going to be, okay, well, how do we deal with that situation on a road, on a public right-of-way that doesn't even have a street? And so that's the concern, that's just one concern that we have. And then the Public Works Director has provided several concerns of his own that I've provided to you in your agenda packet, 2 separate emails to you about this issue as well. So yes, granting this variance, both of them tonight per this application as requested, would allow them to have 2 single-family homes on those properties and be able to get those permits. And use the right-of-way as their front, basically. Then the question about whether they want to put in a driveway at their expense that come from Alpine, for example, through our public right-of-way to their properties is probably not going to be accepted by the city. And so that's a whole nother issue now. So let's say the scenario is the vacate resolution is null and void. We're back to a public right-of-way that is owned and maintained by the city of Titusville, and we have a property owner that's asking for the right to build a driveway through city's public right-of-way, not to city standards. That's another issue that still needs to be resolved. But that wouldn't be resolved here as a result of approval of this variance.
Okay.
And Kevin, correct me if I'm wrong in anything I mentioned about how that public right-of-way would be maintained in that particular scenario. I think there's just a lot of questions that would be open that we wouldn't be able to, we'd have to resolve as we go through the permitting process. And that's why I think the city council, we have that condition in there as part of that vacate resolution to deal with all these nuances as part of the approval of that vacate. So we'll go ahead, so the council, I think, was saying, go ahead and we'll allow you to take it. But you got to deal with all those issues that may come up as a result in order to make it a clean transfer of title and vacate of that public right-of-way for private ownership.
Okay. May I ask a question of the applicant then, please? Sure. In hearing what you just heard stated, would that be something, if we were to approve this, is that something you would be willing to deal with? Well, you're going to have to deal with in future. You understand about that, about the driveway, paving, whatever, on the public right-of-way?
I heard what Brad said. There are several things you have to do when you build a house, and that becomes a very minor issue to resolve compared to all the others. Unless we can get past the first 3 hurdles, we never get to the finish line. I would, if I may, try to help clarify. Yes, council approved a vacation of the right-of-way with conditions, and we have the 180-day deadline, which will be sometime in April. If this is approved tonight, this gives us a right to a building permit, and we won't be back to see you, and we won't be to city council. The other issues are a lot split, and the other things are all administrative things which we can resolve.
Okay.
There were no more variances. This does it. If this is denied, we have other options available to us, including complying with the conditions of the vacation, and we'll reassess our costs and our probabilities and decide after that. So we need to resolve this issue tonight, and this issue tonight is a request to simply build a home on existing public right-of-way which has a dirt street.
Are there any other questions of this applicant while he's still
If-
here?
If I can make my presentation when you're through.
Yeah, we're getting everything all cleared up.
Sure, I just-
And so if there's no other questions, then if you have more to add or to
Didn't want-
enlighten it, I mean, hopefully this is something new from what we've already heard.
Very briefly, sir.
Very good, thank you.
No, we're not going to rehash the old stuff.
Thank you.
But just to try to put it in the right context, we spent a lot of time at the original hearing discussing what was a street, what wasn't a street. And I have a different opinion of what a street and what the code requires in staff. So instead of filing for an appeal to the staff decision, we discussed it with staff and agreed to file for this variance. So the issue really got really confused at the last meeting, and some of it was the fault of the applicant in the presentation about other streets, et cetera. But there again, we have a difference of opinion, and we're assuming for the sake of this variance that they're right, therefore we need a variance. If I were right, we wouldn't be here, we wouldn't need a variance. So that's why we're here. And I understand that we have a difference of opinion. But at the last meeting, we had the hearing, I was asked to make a proposal on certain conditions to improve the driveway across the roadway and whatnot. And that's what the conditions that I submitted, and they were rejected by staff out of hand. No one got back to me telling me, well, what about this or what about that? Staff has always had a hardline position that we got to put in a fully improved right-of-way to current city subdivision standards, and that is ridiculous, it's expensive, it's punitive, it's more than man can afford. So there again, this is simply, can we build on the street as it exists? I believe that should be done, and I have one other thing that I'd like to make a matter of the public record. The city of Titusville recently issued a building permit on property at 4145 Heller Road. The property owner is Anthony Petit, A-N-T-O-N-Y-P-O-T-E-E-T. Heller Drive is a dead-end street. It's not the city standards. It has a stabilized roadway. It has no curb and gutter. It has no sidewalks. It has none of the things that staff is trying to force upon my client. It's unjust, it's unfair, and it's discriminatory, and we object to it, and I want that to be clearly a part of the record. And we'll await your decision. Thank you.
Are there any more questions to this applicant? Okay. If that's the case, we'll close the public hearing portion of this meeting, and we've had some input earlier, but is there any other discussion or a motion?
I have a question of staff on the applicant is maintaining this section is vacated and they're maintaining this, how close is this area to the city's infrastructure that may require the city to come out and occasionally put culverts in or do whatever, in which case this road surface that the applicant is maintaining will be severely compromised, I would guess?
Sure. One of the conditions, excuse me, one of the conditions of the resolution was that the applicant would provide a survey of existing utilities. And the reason for that is, I'm going to refer you to page 19 of your packet. There's an aerial attached to the staff report. It was provided by the applicant. And it shows in yellow squares the dimensions or proposed layout of the lots after all is said and done, if approved with variances and with the lot split. And you can see on the right side of the properties there that are colored in, they're outlined in yellow, that wheel tracks through Parker Drive, through the public right-of-way.
Correct.
You know, on our inspection, I went with another staff member from Water Resources, and we walked that right-of-way, and we took pictures around that cul-de-sac there at the end of or not cul-de-sac, rather, the end of Alpine Lane. And, you know, there are a lot of infrastructure out there. There's a water main, there's a sewer main, there are drainage facilities out there. And we could not tell exactly where the edge of the property line and edge of the right-of-way really start to begins. And you can see that this curb on Alpine going southbound, going right, the southeast corner, when you're on the street, you can see it. I mean, you can't see it in the aerial I've shown you here. But I can't tell if that's in the right-of-way or in the property or what portion, you know, I just don't know where that is. But we could easily see that there was at least, I believe, a sewer or water main line, I can't remember, going underneath that two-wheel path there, or at least adjacent to it. So, and I don't know where they're proposing, if they want to in the future to put in a driveway, how that will impact that infrastructure. In conversations with the Water Resources Department, when you have to repair one of those utility lines, it's a significant repair. You have to dig a very large area in order to get there. It's not just put in a driveway and then right next to it I can just dig a deep hole to get to repair what I need to do. So it's going to be very difficult trying to determine where even a driveway would go around these lines. And so that's one of the conditions that the council approved with the resolution, that the resolution will become effective. One of the conditions is that the applicant will provide those locations for us.
Thanks.
Mr. Chairman? I mean, Mr. Ward is-
Yes, you may respond. Thank you.
Just to clarify, I'm not being argumentative, we would happily agree to that condition that we provide the survey so the city knows exactly where the utility lines are. I've been on the property, I have surveyed the lots in question. We can easily locate the utility lines. We do it all the time and show where they are, and a driveway can be constructed without interfering with those. And we had agreed as a part of the issue before council to do that as well, and the driveway be placed to the satisfaction of the city. We will happily cooperate with that.
Okay.
We're not here to cause a problem, we're here to try to solve one.
Okay. All right. Well, hopefully that answered a question or two. Thank you, sir. All right. So I'll bring it back to us for a decision. Requesting a motion, please. Or comment. I can't make a motion, sorry. You still reading?
Yeah.
Okay, you're still reading. So we will take a moment and do further study then, due diligence.
I have another question of staff, if that's okay. I'm wondering if the other lots that are on what are referred to as Parker Drive, that would they end up in this similar situation? The property owners of those lots electing to build? So would they need to be doing another 300-foot extension from Capron Road to those lots?
Capron Road, so are you talking about Capron Road or
Yeah,
that segment
well,
of Parker?
There's some adjacent lots on the two lots the applicant is asking for, correct? Is that right? Maybe I'm misreading.
No, let me refer you to page 20 of your packet, and there's a zoning map. You'll see the two properties that are currently, as they configured today,
Right,
highlighted in a hash, or they're signified in a hatch,
right.
hatching there. I believe you're talking about the parcel immediately to the right, at the southwest corner of
Yes,
Capron and
yeah,
Parker Drive.
To the east of,
Okay.
right.
That's one single lot.
The whole segment there of Parker Drive is unimproved, except for the ends of Capron and Alpine. If the request for the vacate that was approved of the resolution back on October 9th only includes that portion of Parker Drive in front of those subject properties.
Okay.
Does
That's
not include,
That actually was what my question was, is if the vacate covered the entire extent of
No.
Parker Drive or just here?
and just so you understand, the way a vacate works, is that portion of that vacated right-of-way that is immediately adjacent or in front of that particular parcel becomes part of that parcel.
Understand, right.
So it will become split if it's, all the conditions are adhered to and it's vacated and recorded. That vacated portion becomes split and part of each of those new parcels there, those existing parcels. Then the applicant will need to go through a process of lot split process with us to figure out the transfer deed title of the new, creating the new lot and,
Right.
and whether they want to do a flag lot. That's a whole nother issue if they want to go forward that way. But that was dealt with, I mean, the vacate resolution it was approved, and so those conditions are still out there that need to be adhered to. That's separate. I think what the applicant's asking you to do is consider this variance application separate from that.
Okay. Thank you.
Well, up to this point, I haven't expressed an opinion, but since others have, I will express my opinion, which I can, correct? It is my feeling that to approve this particular request, knowing that still building department has other requirements and all that will have to be adhered to complete the building of the said property. So if he can meet all those requirements and all that, I personally don't have a problem with approving this request, knowing that these other standards are there in place. Any other comments or thoughts?
Would that not be going halfway with the looking at it, or only part way?
I'm sorry, what?
We're not looking at the full depth of the whole thing. We're only looking at
No,
the
we're only
piece.
concerned with what we're voting on tonight.
Right, but
And,
how is it going to affect other places, other things?
well, it
That would
only
be my
affects
big
Parker
concern.
Drive tonight. That's all we're discussing.
Right,
This has no effect on any other, we're specific to a particular location. So this is not a citywide
right.
whatever, and what the applicant brought up about another property, well, it has no bearing on this, because this is specific to this location. What happened with that property is whatever happened, it's not before us. So, I don't think, in my opinion, that it's going, like, somebody picks another street somewhere else, so, well, they did it over here, it automatically becomes official with me. They would have to come through the same process. And council is nodding, so they agree.
I make a motion to deny variance 6-2018 on the basis that there are no special conditions or circumstances existing that are peculiar to this particular land.
There's a motion been made to deny. Is there a second?
I'll second that.
May we have a roll call, please?
Member Johnson?
No?
Member Smith Rodriguez?
Yes.
Member Kilpatrick?
Yes,
Chairman Taylor?
I'm voting no. So that motion failed, is that correct? All right. That motion has failed. And as everyone knows here, it takes 4 votes to pass any motion before us.
It takes 3 to deny a motion.
Well, we didn't have 3. To approve, I'm saying it has to have 4. To deny, that is correct, 3, but we didn't have 3. I guess, all right. So that was denied. Do we have another motion?
Now, actually, I just would like to discuss what the denial motion. Were this to be denied, what recourse would you expect the applicant would have on this property? In other words, if he wants to construct 2 homes, and realistically, because I think the staff, there was a variance required even like for the flag lots, and So there are variances required, period, to make this property useful. I mean, truly to be buildable. There has to be a variance of some sort. We're only really discussing what that variance is and where the access is at. And my feeling is, I mean, this is a little bit of history. That path, or whatever you wish to call it, is named Parker Drive. So to me, the intention was, way back in year dot, whenever all that was put in, that would be a street. The fact that it's not a street now, or doesn't adhere to some of the standards, is, to me, it feels like we're basically talking about a money issue connected with the city. And in other words, there's a big cost burden which hasn't really been qualified exactly what that cost would be to the city to actually make this an unimproved roadway. In other words, it's not paved. There are other dirt streets in Titusville. I've been down some, and I think the applicant stated he lives on one. So a dirt street is not anything unusual for the community. So it's just a matter of whether, in the case of, do we allow variance that goes on to an improved dirt road that the applicant has agreed to partially maintain or fully maintain, or do we look for a variance that's going to require flag lots, in which case the applicant still has to maintain those roadways too. And in both cases, they require variance. It just seems to me that in order for this property to truly be useful, it seems to me like the proposed conditions reflected a reasonable compromise that doesn't require an inordinate amount of expense on the city's part, although there may be some. And the property owner has agreed to maintain that surface. So
Well-
it seems like a reasonable compromise to me.
Your original question, which I don't know, I felt like it was posed to me when you looked over here, was what do I expect the applicant to do? At the end of the day, we can't control what he does when he leaves here. If we grant this variance that says that he can build on an unimproved public right-of-way, and I looked at the definitions, and I see what street is, and I see what public right-of-way is. When he leaves here, we have no control over whether he complies with conditions, even if we impose conditions, or council imposes conditions, or the city and the applicant get in a war over utilities. He had a pending variance for a flag lot, which I thought was a pretty smart idea that allows him to actually use his property better. His property is already being used as it was intended to use, with a residence on it. The fact that it was a large property that has the ability to have 2 other residents on it is neither here nor there. He's getting proper use out of the property. He wants better use out of it, which I respect, and a flag lot would have done that. And if I recall the applicant or a witness's testimony at that first hearing, I believe they said that they didn't want to have that a flag lot because it didn't want to burden any future property owners who may buy it. Well, and we can't control that either out of here. So the other variance that was withdrawn, and I don't know why it was withdrawn, I thought that would have been a better solution than all of the unknowns that happen when we walk out of here. And the bottom line is, this code requires frontage on a street. And I understand the definition of street includes right-of-way. And I understand the definition of right-of-way says land reserved that could be potentially used as a street. I said this the first hearing, and I'll say it again. If they wanted it to look like a street, they needed to make it look like a street. And at the time the street was deteriorating would have been the time to deal with the city to keep the street a street. No one wanted it a street. And that first testimony, all the witnesses like to play football out there and have a good time on that piece of property, and that was their use they desired at that time. The fact that they've changed their desire to have a different use does not mean that the code is no longer applicable. I think there are too many unknowns that are well beyond our control, and the code is clear that it is not intended to have a particular property on that, or property with frontage on an unimproved, it's a dirt road. The flag lot would have been a good idea.
I see you coming forward. Did you have any comments that you wish to add to this, sir?
Sure. When
Should
the discussion
identify-
is,
Identify yourself, please.
oh,
for the
Kevin Coke, the Public Works Director for City of Titusville. The discussion, we talk about a private entity maintaining a public right-of-way, we don't allow that. The city's a liable party, so we maintain our public right-of-ways and our public streets. We don't allow private entities to do them. Part of our concern with issuing a building permit on unimproved right-of-way would be the recourse the city would have to improve the right-of-way, because we can't introduce the public to a two-path, unusable roadway. So we'd have to add a roadway, add signage, stop signs, go to E911, because once we have a house there, now we start to use it for our purposes too. So that becomes our liabilities and our ability to improve a right-of-way. So that's when we looked at this as why we didn't agree with the staff at the time in approving this was, once you issue those building permits, now I'm gonna go grade a road, because now I'm introducing the public to it. The mail carriers, everyone else has to start using it. So now we have to make a road, maintain it, and absorb all that cost through the taxpayers of the city, normally borne upon by developers. The city doesn't build roadways. We do improve them, we don't build them. Why the road fell out of recourse, I don't know. I've been with the city for 12 years, and it was never listed as a roadway we maintained when I came to the city 12 years ago. I know this entire area was paved under assessments, so the city split the cost with the homeowners to build all the roadways in the subdivision. What our understanding was, when they did not have a house, they did not apply an assessment to it, so the roadway was never improved during that program. Those obviously happened quite a while ago. But just to add, when we talk about, and when the applicant proposed to the city to make improvements to right-of-way and take maintenance on, we can't do that. You know, we can't allow someone else to maintain our liability. We would still, even if there's whatever ironclad legal proposals are made, we'll still be a party to that suit over liability. So when we reviewed that with our city manager, that was what we came back with.
Okay. Thank you for your input. Counselor, what do we do? I'm sorry, I was just, we either have to say yes or no. We can't just let it go away, can we? Can the motion be restated?
I can.
All right. So is there a new motion or a restating of the past motion? Now that you have something in your
I
mouth.
put a lifesaver in my mouth. I move to deny variance 6-2018 on the basis that there are no special conditions or circumstances in existence that are peculiar to this property.
We still have a second to that motion.
I'll second that motion.
All right. May we have another roll call, please?
Member Johnson?
Yes?
Member Smith Rodriguez?
Yes.
Chairman Taylor?
Yes.
Alderman Kilpatrick?
Yes.
Okay. But officially, the motion has been denied, sir. So.
Thank you for your time.
It has been a time. Thank you. All right. We will move on to, what is this? Questions. Get back to the top of the scale here. I'm sorry. I'm still computer challenged. Okay. We have no other new business. Is that correct? Correct. Shakings of heads. Do we have any petitions or requests from the public that wish to make an announcement? Oh, okay. Report, staff. Anything to enlighten us on?
You just had one variance application that was tabled at your last meeting to this meeting that was withdrawn.
Yes.
So that's why you only had the one agenda item tonight. We currently do not have any agenda items or applications submitted to us for your next meeting, which will be on January 23rd, but we'll definitely ask for your presence if we do receive one.
Enlighten us on that.
So January 23rd is your next meeting.
Very good. Counselor?
I do have one brief request, if I may. Am I out of order? That's okay.
My report is that if you have not already heard, there is one opening that has vacated since your last meeting. Mr. Tony Ortiz has resigned, and he says that it is with great regret, but he must withdraw his appointment to the BAA due to professional reasons, and he has accepted an opportunity That will keep him away from Titusville for the foreseeable future, making it virtually impossible to attend the meetings, and he wishes you all great success and blessings.
Right. So that leaves us with an alternate and a full-time position still? Is that
Correct. There are 2 vacancies, 1 alternate, 1 regular.
So if any public has stayed up with us, we would more than happy to invite applications or requests, or call us and we'll tell you how hard this is. I've had a request from the public to speak one more time. Yes, sir.
Very briefly, before you end the meeting, I would like to put on the record a request that I've received a videotape record of this meeting, and I'd like to make sure that the city attorney and city clerk are aware of that, and I'll follow that up with an email, but I want to make that on the record.
Very good, sir. All right. Members, do we have anything to report? No. No? And I just say happy holidays and Merry Christmas, and as we take a sabbatical for a while, and hopefully by next time we meet, we'll have an applicant or 2, and we can go back to full staff. All right, if no other business, and we will call this meeting adjourned. Thank you.